At its most basic level, the role of the criminal justice and prison system is to ensure the protection and safety of the community and to administer those consequences which justice demands. However, in a compassionate society, we do not simply give up on offenders and lock them away forever. We work towards their rehabilitation and, where possible, their re-entry into society. But our compassion must not come at the expense of community safety. The purpose of an extended supervision order is to ensure the safety and protection of the community, while also working towards the rehabilitation of high-risk sex or high-risk violent offenders. The extended supervision order has more than 40 conditions, including wearing an electronic monitoring bracelet, attending drug and alcohol rehabilitation, and other harm mitigation actions and conditions on release. In New South Wales, an application can be made for an extended supervision order for certain offenders following the conclusion of a term of imprisonment. Extended supervision orders may be sought in respect of high-risk sex offenders and high-risk violent offenders if the person has been sentenced for a serious offence, as defined by the legislation, essentially serious offences of a sexual or violent character, and the Supreme Court is satisfied that releasing that person at the expiration of their sentence would pose an unacceptable risk of further offence. This bill makes two changes relevant to the extended supervision order and to the way in which it contributes to community safety. The first change includes strangulation as an offence, which would allow a high-risk offender to be considered for post-sentence detention and supervision under the Crimes High-Risk Offenders Act of 2006. Strangulation is a violent, often sexual offence and is a prevalent feature of domestic and family violence. It is a predictive risk factor for future domestic violence. As such, the recognition of the danger, especially to women, by extending the definition of a serious sexual offence to include strangulation, which this bill provides, is a welcome addition to the safety of the community. We support this change, which builds on the Coalition's work against domestic violence. The second change this bill makes is to address a technical sentencing issue. Offenders typically will be charged with multiple offences and receive multiple sentences, which may be aggregated, so there is no delineation of the commencement time for each individual offence. Sentences may also be served concurrently. Not all the individual sentences an offender is serving will satisfy the grounds for an extended supervision order. And questions have been raised about the timing of when an order can be sought. The Supreme Court decision in New South Wales and Avakian raised a concern that in order for an extended supervision order to be sought, the timing of the application must be immediately consecutive to or concurrent with a sentence for a serious violent or sexual offence. In aggregate sentences, this may not be able to be determined. In sentences served cumulatively, the less serious sentence may technically be being served when the time for release is drawing near and the extended supervision order is being sought. This amendment will clarify that if part of the sentence being served by a high-risk offender would satisfy the grounds for an application for an extended supervision order, such application may be sought at any time in the whole of the sentence period. Importantly, this change will not detrimentally affect the rights of prisoners, but will allow for greater certainty as to when applications may be made for such orders. The balance of security, rights and rehabilitation is maintained because these orders will still only be available after a careful review by the Supreme Court of New South Wales. The safety of the community must always be a priority for Parliament, especially the safety of women who are disproportionately affected by sexual and domestic violence offences. We are happy to support this bill.
Ms Abigail Boyd.